Filomena Chirico, very warm welcome to Digital Markets Research Hub. You've been one of the co-founders, co-creators of the Digital Markets Act, and we discuss various aspects of it. And now we finally have an opportunity to look at the enforcement of this new regime, its main achievements, its main turbulences eventual, and the level of satisfaction within the Commission, and to discuss these issues with you. And there are several things which obviously resonate in the mainstream generalist headlines of newspapers, and who would be the better person to reflect upon these issues. So maybe we can start with asking you to reflect your views on the latest development within the DMA regime.
Thanks, Olive. I'm very, very glad to be speaking to you today and to have this video in which we can have a nice conversation on the ins and outs of the DMA today. As you said, I've been involved also in the origins of this legislation, and now I'm involved in the implementation of it together with my colleagues in a team that is growing bigger and bigger by the day. So you said what's the latest development? I would say the start by saying that the DMA is a complex framework. It's a new form of a new generation, if you want, of regulation. You know, I like to say that it's one of my twin sisters. I was working on the DSA and the DMA, and so I call them the twin babies, and they are both girls. So they are a new form of sectoral regulation which didn't exist before. It's the first time that we have a digital sectoral regulation, and I just read that also the UK managed to approve in the parliament now a new digital regulation. Digital competition, I would say, is more in the UK than digital regulation, and that words are important in this field, I would say, because we had a long reflection on making a new regulatory framework and not just to change the way we apply competition law. That's a regulatory choice. You know, in the US, they still apply competition law also because they don't have anything else. In the UK now you have a specific new regime that will kick in very soon. So I would start by saying that in a way, while the DMA has been perceived as has been seen, I mean, strictly speaking, is a list of obligations that nevertheless, beyond the list, this is a plan, this is a roadmap, and this is a roadmap towards fairness and contestability, which are the objectives. So even if sometimes there is a tendency to see it as a collection of past cases, and indeed some ideas, they come from past problems, past cases in competition law, although not only, because we also had a number of other more regulatory initiatives that are, you know, in the family we have the babies, the girls, but we also have the uncles and the aunts, and we have the competition law cases, but we have the P2B regulation. It's some kind of uncle sitting down there and influencing the way the girls are growing. So just to say, it's something that we should start also looking and thinking into a more general and abstract way, which is the words that also the Court of Justice used recently in one of the cases, and it resonates to my law studies, that the law is not to solve a specific case, a problem-specific case, but is general and abstract. That means that even if one or more provisions come from a specific experience, the overall impact and the overall effect, this will go much beyond that. So we're not necessarily into the business of the specificities, and that is something that, if you ask me, so the latest development, how it's going, it's something that sometimes I feel the lawyers out there are struggling with, because that's not what they are used to. They are used to having a case, they're used to having a discussion on a specific problem, and now we are talking about a new framework. So I'll say the first thing that is happening gradually is the change of the mentality in the way we look at the DMA. And sometimes for some, let's say, in good faith, it's difficult to move forward. Sometimes it's not in good faith, but it's because it serves certain specific interests that one would still want to look at the DMA with the eyes of the of past cases in which maybe lawyers had a different life and a different experience. But I want to say, so how is it going and the latest development? We have now almost actually we hired the number of people that we were aiming at. Actually, we went slightly beyond the 80 people that were foreseen since the beginning. And allow me to be a bit straightforward. We are damn serious about making it work. So that's like the biggest motivation I've seen in the like, it's a relatively young team, but they really believe in what we are doing, and we want to make it happen at all levels, political level and case handlers level. Just to say, is it working yet? That's what, is it functioning? I would say, because that's a question that is being asked quite regularly, and the answer is mixed as often. To say like that several things are already changing, and we have seen APIs being put out there for example, for data portability, or we have seen new rules to allow app stores into systems which didn't never allow them before. So things are changing. Is it all working? Well, if it all was working, we wouldn't have to open on non-compliance cases. But I think it's important to acknowledge that things are changing, that companies are starting to come to terms with the fact that they have to do what the law requires. Of course, it's not unusual that companies might want to do the minimum instead of the maximum that is needed to comply, and then it will become a matter of discussions and dialogue. But I don't want this to be a monologue, so I'll leave it. I'll stop here.
It is hard to intervene here because it's quite a rare situation when I agree with everything a guest reflects upon. So I think you are academics yourself, and you know, as an academic, you cannot be a previous, so you still have it mind of trying to taxonomize and categorize things. So if my observation is correct, I see several camps within the DMA supporters. I leave aside the critics, but let's say within supporters, and some expect more comprehensive enforcement, and they would expect all the catalog of obligation being the more the better logic, so to say. And other more cynical camp would see obligations as tool, and I would rather subscribe myself to the second camp, as a tool to achieve something more strategically long-term. And from looking at this perspective, the size is not decisive because you are not expected to engage in all potential hypothetical instances of non-compliance for its own sake. You can thematize things which are relevant for more strategic vision, and thus 80 people sounds like a good team. The more the better, of course, in terms of squad, but it's still it's more about quality and the vision, strategic vision. And also I would expect the results not popping up immediately. I would see it as a long-term game, and that's why hearing criticism that the DMA doesn't deliver already from day one, so to say, it sounds quite kind of a little bit too optimistic from those who expect it to change the law of gravitation or something. But we hear the criticism, and some want to, or there is kind of persistent echo about the opening the first non-compliance cases before the last the stakeholder workshop, or compliance workshop rather, is on Monday. Has been passed. You already announced on Tuesday in March non-compliance investigations. Is there any symbolism? Should we try to decode it, or should we focus our creative energy to something more prudent and relevant?
Look, I would not read too much into the specific date in which we opened the investigation, because also we are in administration, we have processes, and the important thing that we wanted to signal with the openings is that it's not even 3 weeks since the deadline for compliance, and we are taking actions. And if you look at what actions we are taking, is actions that are mostly grounded on things that are more clear in the law. It's not elements or situations that would require long investigations into fact-finding in a way. So there are, I wouldn't say all of them, but many of them are referring to things, I mean, what the law prescribes and what we have seen happening in concrete terms do not correspond. Now, to say why did it come so quickly after non-compliance, after the deadline for compliance? You should have waited until what? I don't know, because actually we have been discussing with the gatekeeper for since designation, with some of them even before we started already, because they knew they were going to go to be designated, and so we knew what was coming. Of course, we cannot be sure, because until they send us the compliance report and they publish it, then we don't know what's the final position that they're going to take. That's the date, the 7th of March, when they are, the gatekeepers were obliged to put it out there, how they are complying. And since then, we saw that what we had seen before was being confirmed. And then it didn't take much longer. Plus, by the way, we had workshops, so the same gatekeepers explained what they had put out. So also the explanations and the answer to the questions did not add anything to what we had seen before or what we didn't know. So we opened. That's it was very straightforward for us. So I wouldn't find the symbolism behind it. But as I said, I think the most important thing is that we were fast because we are damn serious.
Another question related to possible eventual demystification of some symbolic vocabulary, at least regulatory dialogue. It has been presented to the broader competition cluster, the proposal itself, as an attempt to recalibrate this significant asymmetry of information, of resources, and within the ex-post competition law enforcement. And the regulatory dialogue is considered as a soft or multi-log, given that so many stakeholders would be engaged with. So I wonder, should we rely or consider the softer tools as being the main mechanism for successful compliance with the DMA and for successful performance of the new regime? And what would be the main elements, in addition to what we already somehow see: compliance reports, compliance workshops, specification decisions within Article 6.7, or with the obligations of Article 6.7? What other elements should we look at? And maybe even an additional question: do you feel sufficient competences or bargaining chips within this dialogue? Would you prefer the back door of private enforcement being hermetically sealed, or you okay with it being half open, or is it impossible to seal?
Yeah, look, I think for me, the regulatory dialogue is an important element of the DMA. I would even call it a backbone, the backbone of the DMA, because in a way, the nature and the regular life under the DMA should not be litigation, should not be confrontation or the accusatorial system, because the whole logic of the DMA was to get out of the system where, like, I'm investigating non-compliance by default. I am monitoring compliance by default. So it is a dialogue by default. The non-compliance we had to open because if there is non-cooperation since the very beginning, we have to show that we are actually not hesitating to use the whole toolbox, but the non-compliance is just the last bit of the toolbox. So you start with, you mentioned some of those tools in our toolbox. We did public workshops. That's something that doesn't exist in the antitrust experience like that. But we did also closed door roundtables where, like regulators do, we called the incumbent. Let me use some terminology which doesn't belong to the DMA, but we call the incumbent, we call the access seekers, we put them around the table and they discuss technical matters. That's also part of, that cannot be public because otherwise it becomes a discussion on perhaps business secrets, which cannot be, or technical things which are not for public disclosure yet. So we had to keep it like this. And that's not only that, we have specifically in the DMA, the compliance report, which is the longer version that is sent to us, and the public version that is made public. And I'm using a lot the word public here, because also that's something that we try to make clear since the beginning in the DMA implementation world. We are not keeping things between the regulator and the gatekeeper. It's not a one-to-one conversation. It's with third parties. It's with users more generally. We speak a lot also with civil society also to hear their input and the impact on users and on consumers, because also that's not something that we can decide, you know, with just the wet finger strategy. So it's something that, and we have been also very vocal when we have been, very vocal or also very open when we did something. And I remember being asked some questions like, oh, the commissioners went out saying that you spoke to Apple and you asked them this or that. And it's like, yeah, that's what the regulators do. It's because this is about the overall regulatory supervision, and the fact that we have a counterpart in the companies, which is the compliance officer as well. So we have all sorts of tools. We another thing that came out on the 25th of March, we sent to most of the gatekeepers also retention orders. And so the order to preserve and to retain certain type of information, but not because we have an infringement or a non-compliance case open against them, but because we want to assess compliance. So that's a very important change in the attitude, and perhaps we are not yet there, because there is still this confrontational attitude that comes sometimes from the companies, not all of them, but still, like the ordinary reflex from previous experiences. But we are in a new experience, and the last one, which actually you started with, the specifications. This is something that is totally new, and we haven't yet started using it, because then it's something you spoke about our asymmetry of information. We want to use when we have enough information on what we are asking the companies to do. But that doesn't mean we are already studying and preparing on to use them, because it's also fair for some cases to say, like, yeah, but Commission, tell us what you want us to do, because we can do various different things. So what would be satisfactory from your perspective as a regulator? And we are preparing to move in that direction for some of the different strengths of the DMA. So how they say, like, stay tuned. Specifications might be the next thing on our plate.
But would you be on the last point? Do you feel that you have sufficiently diversified toolbox in terms of telling what to do? So can you even go in beyond specification decision in terms of eventual compliance or narrowing down the obligation of Article 6 and 7? Can you use it as a leverage to somehow to tell, we want you to do this, and this? Is there any room for such broader, because why I'm asking it, because that commitment decisions would be one of the possibilities, or the logic of commitment decision refined further, making the Commission the first mover in proposing the potential compliance mechanism would be an avenue to do the job within Article 5, but also beyond. So to cut the long story short, do you feel that you have already a sufficient toolbox, or something missing is in your regulatory framework?
Look, I think it's fair to say we have been enforcing the DMA for a short time, but let me say we are already taking notes, or where we see some things that we might find more difficult to do under the current system. So in case when we do the evaluation in a couple of years, if there are things that we have discovered, there might be gaps in our toolbox, we will be thinking about maybe pointing them out for of course, for the legislators to decide. But we are at the moment still experiencing what we have in the DMA, and we haven't even exhausted yet. As I said, the specification. I mean, if I go back to negotiation, there was a proposal in the proposal to put also commitment as part of the toolbox, and the Parliament and the Council, they kicked it out of the text. So this was a conscious decision, in part for what you say. It's not for the Commission to put out, or in the case of commitments, to make binding. It's for the gatekeeper to comply. So you just have to comply. You tell us what you need to comply, and if we are not happy, then we will tell you, and you have to change. And we have also, that's what Commissioner Breton always liked to use. The toolbox is completed by the sanctions. And the sanctions can go very far, and not only in terms of fines, because as many people say, these are big companies and may not care about the level of the fines, although I assume that they do. But there is more to it. There are, of course, the classical, there are the daily penalty payments that can be imposed for non-compliance. So imagine we find non-compliance in something, and there is an attempt to more compliance, but we are not getting there. That's a lot of money if this is what the company is planning. I hope not, and I don't wish so, but that's one thing. And we have already opened 5 non-compliance cases, and against different companies. We are also, we have said that we have launched pre-investigatory steps on another 2 areas. And it takes 3 non-compliance to trigger the systematic non-compliance, which then has very, very serious consequences for the company. So the toolbox is, and the enforcement part, the sanctioning part, is what allows to give the teeth to the toolbox that I mentioned before. In a way, they are there so that we don't need to use them.
Exactly. I fully agree. It's something. It's a stick on the wall which you use as a, the very present. One step back, if I may. Your intellectual pedigree is competition law, but you've been working in DG Connect. So you witnessed the DMA being created as a harmonious co-contribution of 2 different ways of doing public policy. We know already what's the elements, the genes of competition policy. In terms of sector-specific regulation, telecommunication policy, I imagine, would be one of the examples, one of the co-contributors. Do you think the DMA also absorb, what would be different between the DMA and the previous liberalization kind of type of regulation? Is it another step of regulatory framework, or a kind of incremental refinement?
Well, I think in terms of, this is purely for me now, I'm speaking more with my academic hat, if you want, than the enforcement hat. In the regulatory framework for telecoms, you have more flexibility to impose certain types of remedies to companies that fulfill the conditions of the regulation. So the regulator can target in a certain way the access obligations, or to say how they need to what does it mean, the unbundling of the local loop in concrete terms, for example. I would say the DMA, for the sake of legal certainty, tried to do something much more specific and say, like, if you have, of course, there is some flexibility, especially in Article 6, on what to do, how actually to implement the specific obligations, but it's not for the regulator to devise remedies in a way. So there is a different logic. But I want to also draw another parallel. really at this stage very much an academic parallel with the telecoms regulation. Is that if you think of, and that also refers a bit to one of the points that you made before, the big pictures versus the obligations. If you look at some of the obligations of the DMA, take the obligations that pertain to the operating system, for example, or the app ecosystem, more generally speaking. In a way, you have gatekeepers. They are gatekeepers for determination to end users. So if I think telecom terms, a telecom operator is not a monopolist, but is a monopolist when it comes to determination to its own users. So you can draw a parallel like this, but then the difference is that in telecoms, what you are looking after is the interconnection between different operators, so that there is no monopoly anymore on termination. Not exactly like that, because then it implies price regulation and all sorts of other consequences. In our field, we don't want interconnection of competing gatekeepers. What we want is access to the end users. And access to the end user is not something that is written in the DMA, but is the consequence if you take the web distribution, alternative web distribution obligation in Article 6.4, you take the interoperability obligation in 6.7, you take the anti-steering provision, you take the 6.12 obligation on front access to app stores. If you put all together, this is fair access to by business users to the end users that are in the control of the gatekeeper. So, and it cuts also across the CTS, the call platform service, the CPS of the specific gatekeepers. So if you see, there is a lot that I can see in terms of similarities with other types of regulation. So it's not about monopoly, it's not about dominant position, it's about control over termination to some extent.
Yeah. Obviously, as each analogy, you have to take it not literally and not verbatim, not 100%, of course. Yeah, but the trajectory you identified opens imagination and thinking in this way. Thank you for this. And speaking of users, from what we witnessed in the last 18 months or 24 months, we see in both jurisdictions, in the EU and in the UK, maybe in the UK even more so, we see a handful or maybe a few dozen of business users who can be labeled medium tech companies, who know very well the whole cosmos of digital markets. They understand precisely where the pitfalls are, how the gatekeeping position is being, what's the phrase, misused, let's say, historically, and what can be done in order to remedy the situation. And they use the vocabulary of public policy for right reasons. I think it's kind of rhetoric, which because they wouldn't refer exclusively to their narrow interests. They want to make them sound more appealing, and we hear their voice. I wonder if beyond this kind of change of vocabulary, do we also have to consider broader public policy considerations and going beyond the interests of specific, most entrepreneurial business users who manage to succeed in taking over their overall kind of discussion in the DMA area?
Yeah, I don't know if that's the right approach to what the situation you are describing, because I see that there is more and more a sort of a push or a pressure to go beyond the if not the stated objectives, the narrow outlook of this type of regulation, because I mean, let's also be realistic. The DMA has some specific objectives. Now it can be a broader regulatory framework if you look at the combination of the various obligations, and as I said, the roadmap towards fairness and contestability. But there is only so much we can do with the DMA. I also hear politicians out there saying, I think somebody said at some point that this is the last form of light touch regulation. If things don't change, then we have to go much stronger. I would personally, I would say, like, let's try if that works. Now we have it. It's something new. It's something that gives us quite some, as enforcer, quite some tools to make things change. I think it was more of a warning for the regulated entities rather than for the regulator. Make it work, otherwise we change it again. But I think that there is an expectation, important expectation, that things will change as and the more entrepreneurial or the more innovative business users will find a way to go through the procedures also of the DMA and help us, and we need their help, because sometimes we wouldn't even be able to know that something is not working, to change it and to ask the gatekeepers to change. On the other end, it's also true that there are technologies that change all the time. And now, if you ask everybody now, the biggest thing, that the newest thing that is in the mind of everyone is AI. And the question that I get every single time, and the question that I get from students when I teach, is, what about AI? And the DMA is agnostic to technology. So we regulate some services. If services incorporate AI, then we are happy to look into AI. We are obliged to look into the AI that is embedded in the service. So the AI makes a certain type of system change from and become a CPS perhaps, or makes it fulfill the characteristic of a gatekeeper, that we look into it. So it's what I'm trying to say is that this is still quite in its infancy, the process and the system that we have put in place. So it will help to have entrepreneurial business users also to tell us what's happening, and to help us for the things we know and we could foresee already, or the legislator could foresee when they put it in the law, but also to see where this is going, and how the technology is changing the business model in a way that maybe does not fit one-to-one in the letter of the law, but still fits into the objectives. There is quite some interesting work coming up, I think.
Absolutely. I was referring mainly using this model, and maybe it's a little bit too schematic, that if we focus exclusively on business users, we would be refining, improving markets incrementally. Whereas if we look at something which appears to be unrealistic, looking at potential new entrants at the core platform services, unless these are new entrants from other designated or proto-designated gatekeepers, then it sounds most unrealistic and not achievable, naive to expect. But if they emerge in your radar at all, do you think it's plausible? And then, the cascade of other questions emerge. What about geography? What about European? That would be ideal scenario. But what if they come? What if their links are from jurisdictions with, I don't know, authoritarian pedigree, etc. So I imagine this geo element is invisibly present. And what is your relation? Do you try to distance yourself, trying to be more focused on the latter, on more short-term issues, which are so many, and cascade of them popping up continuously, or this broader things are also on your radar at least?
Look, starting from the geography point, for me, the DMA is agnostic to geography. It has, of course, it can only be applied to services that are provided in Europe. But if it's an innovative or an entrepreneurial business user that comes from Korea or from wherever, that offers services in Europe, that's our client too. It's not just because it's, of course, as you say, like if it's a European innovator, so much the better, because we have an interest, of course, in that. But to be honest, we are in contact with companies from really everywhere, and actually what we hear is rather like, but why do you oblige gatekeeper only to change the systems for European users? And then we say, like, that is a limit. We are not limited when it comes to the business users that can take advantage of it, as long as they offer it in Europe. But to be extraterritorial like this, that's not something we can impose. It's something that gatekeepers may decide by themselves, that if that's in their interest, I guess they will do a cost and benefit analysis of whether it's better to maintain 2 different systems or 3, because now, I mean, the UK has a system, Japan has nearly a system. We were in discussions recently with the Brazilians. They also have a DMA in the pipeline. So what's more, I guess it will become an issue for the accountants in the company. So where are the costs based? So in this sense, I think we are pretty agnostic in terms of, as I said, nationality of beneficiaries, with the limitation I said that the impact is for the European market. In terms of, I don't know if that's the representation of what you are referring to, the Schumpeterian type of competition, that the business user is so innovative that actually displaces the gatekeepers. Of course, that I guess is the hope of any regulator, that opens up not only, let's say, competition within the ecosystem, but a competition for the ecosystem, if you want, for a new ecosystem. And I mean, it's not something that we can, I mean, we always say we don't decide on the structure of the market here. We just enable the structure to change if there is somebody who's able to do it. So long story short, again, it's always in the back of our mind that we are not after competition in platform, or if you want, within ecosystem competition, but also to enable getting out. Innovation outside of the ecosystem is something that we would love to see happen. Whatever ecosystem we are talking about.
Yeah. And speaking of ecosystem, obviously, I wanted to ask a question about the latest designated gatekeeper. They were referring to the vocabulary of ecosystem, saying that basically we shouldn't be considered as gatekeepers, but in a broader kind of philosophical sense as a challenger for the existing ecosystems, because we are not ecosystem, at least in the context of Europe, because in the broader context, it appears to be that they are as ecosystem as all other designated undertakings. So what's how useful this vocabulary emerging from strategic literature and dominating the discussions in competition law and policy academic cycles over the last 2 years or so?
Look, the formal answer is that this is not something that the DMA asks us to look into. And that's also why the objection from some, like, oh, well, we don't have an ecosystem, was not relevant for us, because if the DMA establishes that you are a gatekeeper, if you fulfill certain characteristics, and while it's possible to rebut such a presumption, the fact of not having an ecosystem is not an argument that is recognized as a valid one in the law. I'm applying the law. I'm not making the law myself. I'm not making a theory of harm myself at all, to be very, very true to the text of the law. So besides that, I mean, as you said, maybe they have an ecosystem. So it's in practice also a moot argument, because the fact of only having maybe one CPS designated doesn't mean that there are no other satellites around them that are also services. And just to say, there are certain provisions in the DMA that don't apply only if the service in question is a CPS. So it's designated. If you take 5.2, if you take the data combination requires consent regardless of the service being designated or not. So any other service that is part of the offer or of the platform, of whatever we want to call it, of the company, then is subject to the provision, and the same for other provisions. So it's when I used it maybe a bit lightly, the word ecosystem, but not in a legal sense of attaching legal value to it, but to say in a more practical way, like competition outside what is the platform that is offered by the gatekeeper in question.
Filomena, I wanted to also ask you a question. You mentioned it at the beginning that, and we all see it continuously, how persistent the Commission was trying to point out, to stress it, that the DMA is a new start, juristically speaking. We shouldn't infer or refer to competition law case law, and it's a very prudent a move. In the UK, we opted for continuation, yeah, even if in a more kind of autonomous way, but it will be continuation. And thus I infer to the Court of Justice, because understanding how its broader societal role in shaping European law and European integration historically and in the context of competition law, we understand that they can be a strategic player. They can focus on some nuances, on some peculiarities, slowing, discouraging you from, or making the Commission more risk averse, and making, or vice versa. They can say, okay, we understand that it's a new regime, it's terra incognita. We let the Commission do their own mistakes for some time to shape the regime before being more demanding and mandate and prescriptive. You sense the organism. You understand not only the letter of law, but what's the spirit in this establishment, let's say, in this institution and in the context. Can you somehow shed some lights of your intuition? Do you think the ambitious regime of the DMA receives understanding and support from the members of the Court of Justice of the European Union, or it's rather something which you are not absolute, or you would be cautious?
Well, of course, I can't speak for the court, but what I see is that there is, I mean, my feeling is that there is an understanding in the court that this is not only a new regime, but that the idea of the objective of the legislator was to for example, to have a regulatory framework that would allow for a fast solution to issues that would arise. And the court recognized quite fast, the members of the court, they very publicly said, like, we intend to go fast on DMA matters because we understand that there is a need for speed in that context. So I think that there is a recognition, acknowledgement that the new regulatory framework requires a particular way of looking at it that might not be what the practice of competition law dictates. Now, of course, that's not only competition law that plays here. I mean, there are general principles of law. And if you talk about right of defense has not been shaped in competition law matters only. It's been decided in a number of areas. And in areas where you have, like in the DMA, like a tight process with deadlines, as the court has said certain things that are different in a case like antitrust, where you have already, if you look at mergers and antitrust, there is a difference. So the balancing exercise that the court does already in the past has been depending on the characteristics of the regulatory framework. So I imagine that they would do the same thing here. Now, from what we have seen, for example, I was talking about speed. The ByteDance appeal has already, the ByteDance interim measures have already been decided. The hearing already took place, and it was very thorough. I mean, I think you must have seen it online. It lasted for quite, I mean, the whole day, and my colleagues were in Luxembourg for that, and the court had very, very pertinent and very thorough question, showing for me that there is an interest in understanding not only the law, but also how the Commission reads the law, because that's what also will ultimately matter for our decision. So now I think the issue will be coming more that I was saying before, in a regular life of DMA, there is no appellable decision, because there will be compliance, changes in compliance and so on. Only if the Commission takes a position, there will be a court case. So there, I don't know, maybe there will be less decisions taken in the future. And then, I don't know, I actually welcome the decisions of the court, because they will tell us whether we get it right, because regardless of the fact that we say all the time that the DMA is clear and directly applicable, and that's very precise obligation, as usual in every legal text, you have one lawyer, you have three different opinions. So it would be good at some point to have the court saying like, yes, this is the way, or no, commission, you got it wrong, and this is the way. But that for me is also an opportunity for us, because this is the moment where we can afford putting out our interpretation, which has to be, of course, based on the law, and see whether this is the way that the court validates. That's I'm very excited about this. I shouldn't say like I'm looking forward to go to court, because that's not exactly what we are aiming at. We hope to get it right straight away, but it's an opportunity. I mean, the single market was created by court cases much faster than any legislation. So I'm a big fan of court decisions in this respect.
Exactly, and there is a strand of literature in political science, I think, referring to the history of European integration, looking at ghostwriters, how lawyers channel national judges to shape preliminary references decisions, trying to shape the evolution of different areas of your law. Not in 2024, I imagine, but some strategic elements are not out of radar, I think, from both sides, but that's hypothesizing. Another question which has which attracts attention of our colleagues is the role. I wouldn't ask you about elections specifically, but the role of political leadership, let's say, in changing priorities, in instructing the machinery of the DMA task force and relevant directorates. How much is at stake with this election? Do you think we can expect some significant changes of priorities, or maybe it will be more or less compliant, or more proactive role of the Commission?
Look, I think it's, let me say, from my experience, you say I have a competition background at the beginning of my professional career. But in enforcement matters, you can see some change, but not the massive change in directions that you have in policy making, for example. Because, for one, this is a legislation that has been adopted by the democratic institutions now. So it says what it says. If we have to stick to the letter of the law, the margin is, I can speculate to make it slower or to make it faster, but it's not to change really the objective of the way we would look now at digital markets. Now, if I were to speculate, judging from the negotiation experience, I saw firsthand convergence across party lines and across member state lines. The differences were at the margin. Should we add one more obligation? Should we add one CPS? What should the role be for competition authorities? More, less, a bit more, a bit less. But the fundamental architecture of the DMA and the objective stayed the same and were actually reinforced. So if that means anything, for me, it's that whoever comes next is not very likely not to share the objectives and not to share the line that has been enshrined in the legislation as it is today. So I would personally not expect, you never know, but I would not expect big political changes, big changes due to different political outlook. And if you see, even now we have two commissioners that are in charge of the DMA, and I mean, they may not see eye to eye on everything, but on this one, I think they do.
This is really reassuring. And looking in the future, again, reverting back to your academic incarnation, we know that students get huge interest in this development. Competition law, it becomes a truism to say that competition law becomes so topical, so popular, and we can see it as academics constantly. Digital markets and DMA in particular, every student feels that they understand better the nitty-gritty of digital markets because they live and think digitally. Obviously, the narrow question and the broader question. The narrow question: what would you, as the Commission, expect? Which features would you recommend students to train? Which aspects of their job applicants would matter most in the following years? And broader, maybe not to the Commission, maybe for the defense bar, maybe for court. Which elements are currently missing in the long list of applicants which get the post, and some academics get the post in the Commission with regard to our satisfaction?
I have to say I have at least 5 or 6 PhD in my team. There may be normally it's PhDs in law or PhD in competition law or sometimes IO and like in economics. We have a couple of people in the team, and I hope to hire more who have PhDs in computer science. So if I were to, or in data science, data analytics, and I think this is the area which we will need to strengthen more. And in terms of, let's say, law students, now, when I was a student myself, my PhD was a bit of an interdisciplinary one, simple interdisciplinarity, law and economics, but I did it on internet governance, because I've really been passionate about tech since my youth. So I wanted an element of light engineering in my analysis. So that, if you ask me what I would recommend students to take as like a side interest in, would be technological aspects and being able to understand algorithms. Or now I understand it's very common in many, not necessarily in law faculties, but in many course of studies, to learn to code in Python when especially in economics or in biology or in other fields. So this is something that, besides that, helps strengthening logic thinking, because the computer coding is very logical. It helps also if they are interested in this particular field to get, I think, the upper end compared to other applicants. Another thing I would recommend to students now, I've been teaching some courses on digital regulation the last couple of years. It's a bit inevitable, but they come in always, or most of the time, from the competition law angle. And it's time to train to get over it, because whether you'll be a defense lawyer or you apply to join our teams, that's something that needs to be passed on. I mean, we are not doing a market reconstruction because there is no market. You know, the Matrix, there is no spoon. That scene in Matrix. That's what I've been using with my my team. Like, there is no market, so there is no reconstruction. There is no what you have learned in competition, which is extremely useful and extremely rigorous. Try to put it aside and to use the soft skills now to apply a new system, a new framework. So that is something, and it's starting. I have to say that my most recent students, they start asking questions, but how does it, what's the difference between a search engine in the DSA and in the DMA, for example? And how is the GDPR and the ubiquitous, what about the AI Act? And, you know, so trying to broaden, because that's something I remember from me being a competition lawyer or a competition, I wouldn't say even a lawyer, because as I said, I was a bit of a mix, but interested in analysis of competition and regulation. Like get a bit out of what you know, your comfort zone, and all the competition concepts that you know, and think broader. because that's something that we all are striving to do, and this will be the future for the DMA team.
And my last question, you mentioned DSA several times, twin sisters. And I remember they were using as DMA DSA as one digital DSA kind of package. And now more and more we understand that so much is going on in each area. So we don't have enough knowledge, or if we have knowledge, we have general understanding, general track of the development rather than looking at nuances. What's going on in the DSA. Do you see these two regimes trying, as they become more mature, more established, they become more autonomous as well? Or is it important to remain in strong family links between these two? What should be the future of coexistence of DMA and DSA?
Look, I think in terms of pure enforcement, there will be a specialization, because the objectives and the rules are different in the two pieces of legislation. At the same time, there are so many interlinkages that I would say in the future we will not be able to say like, oh yes, we are looking at the algorithms of a recommender system in the ranking of whatever service, whether it's a marketplace or a social network or something else. It's a recommender system, is an algorithm. Is it doing self-referencing, for example, under the DMA? And how does it work actually? How has it been disclosed under the DSA to make it clearer? And how do the various risk mitigation measures impact the fact of having possibly a certain result as a ranking? But with AI, it will be even more. I mean, if certain information are fed into an AI that provides a service which is a CPS, but is also a regulated platform under the DSA, what's the cumulative effect of these things, and how can we actually solve? I mean, the first question will be, is there a problem? What type of problem it is? What's the best legal instrument to tackle it? But you need to have the overview and to understand where to go if some particular form of behavior or an initiative or a new idea strikes you as not exactly right.
And these communicative codes are already envisaged by co-legislators, because, for example, in Data Act, we see reference to DMA gatekeepers, in AI Act as well. So the very rationale of the DMA goes beyond the DMA itself, in a sense. And it's very reassuring, because for people who adhere to more kind of broader strategic perspective, it's a sign that of the regulatory wisdom. Filomena Chirico, thank you very much indeed for this really fascinating conversation. It was a pleasure.
Thank you, Alice, and thanks to all for who will watch the long conversation. It was very interesting for me to exchange.